Mr. Shields, I want to clarify something you mentioned on direct examination. You told us that you didn't do any more work for your grandma after dinner?
I think I drove to the store maybe one more time, but that was about it.
So then to correct your testimony from direct examination, you did leave your grandma's house at least at some point before leaving at 7 o'clock, right?
Well, that's true, but I left to go home at 7 o'clock.
Okay. Well then, Mr. Shields, I want to focus on the accident specifically. Sir, you would agree with me that at the time of the accident, you were pretty distracted, weren't you?
I don't think I was distracted, no.
You wouldn't say that you're distracted?
No.
Well then let's talk about what led up to the accident. Sir, like you told us, you were at your grandma's house that night, right?
Yes,
That
I
day.
was.
You would agree that, like you said, you were running errands for your grandma, right?
I was. I went back and forth to the store a couple of times.
Exactly, sir. You were driving back and forth between your grandma's house and the store, right?
I was.
You did this repeatedly, didn't you?
3 times, I think.
In fact, those 3 times you were driving back and forth between your grandma's house and the store, that made you frustrated, didn't it, Mr. Shields?
Did a little bit, yeah.
In fact, not only were you frustrated when you were driving back and forth between your grandma's house and the store, sir, you would agree with me that you were driving in a hurry, right?
I was in a little bit of a hurry, yeah.
In fact, you would agree with me that on that day, you actually got a ticket for running a stop sign, didn't you?
I got a ticket for running a stop sign. I didn't think that I ran it, but the police officer said that I did.
Sir, that wasn't quite my question. I didn't ask you whether or not you think you did. I asked if you did get a ticket for running a stop sign. And you did, didn't you?
Like I said, yes, I did.
Now, I need you to be very clear for the members of the jury here. Did you get the ticket for running a stop sign before or after you'd been drinking that day?
It was after dinner.
You got a ticket after you'd been consuming alcohol, sir?
I got a ticket for running a stop sign after dinner, yes.
All right, Mr. Shields. Then, moving closer to the accident specifically, you would say that you actually didn't get a good look inside of Mr. Daly's car, did you?
Other than to see that he was slumped over, no, I didn't.
Right, then let's talk about the specifics. You would say the accident took place at 7:37, right?
That's correct.
Said 7:37 p.m., right?
Right.
That's nighttime, isn't it,
It is.
Mr. Shields?
Yes, it is.
And nighttime, we can agree, is, as a rule, darker than daytime, isn't it?
Yes, it is.
It was a little darker outside, wasn't it?
Yes, it is.
Well, Mr. Shields, in addition to that, you think you'd recognize a photograph of Kessel Road if I were to show it to you today?
Lived there all my life? Yes, I would.
All right, well, you've got a binder in front of you. And if you could go ahead and for me, turn to tab 6. And let me know when you're there.
I'm there.
Do you recognize that to be a photograph of Kessel Road?
Yes, it is.
Does it appear to be a fair and accurate depiction of that photograph?
It does.
And sir, looking at that photograph specifically, you would agree that it's looking east down Kessel, right?
That's correct. The direction I was driving.
Exactly, the direction that you were driving.
Right.
And by process of elimination, Bobby Daly would have been coming towards from where that photograph was taken, right?
That's correct.
Your Honor, at this time, we move to admit Exhibit F.
Any objection?
Yes, Your Honor, misleading the jury. May it be heard?
Yes.
Parties have stipulated that this picture was not taken on the night of the accident. It was in fact taken in daytime after the accident took place. Therefore, it's not an accurate representation of what Kessel Road looked like on the day.
Ma'am,
Yes, you may.
we're not at all arguing that it was what Kessel Road looked like at the time of the accident. We're arguing this to show what Kessel Road looks like generally, and as an offer of proof, the only questions I'll be asking about this photograph are about the placement of streetlights, which, unless Ms. Coley disagrees on that point, were present on the night of the accident.
Your Honor, may it be heard?
Last chance.
We're not disagreeing that there were streetlights. However, admitting this photograph into evidence and showing it to the jury in that regard would be misleading them to think that that's what the road looked like on the night of the accident.
Yeah,
Absolutely.
we're happy if Your Honor tells the members of the jury that this was not a photograph of the night of the accident itself. You can give that sort of limiting instruction.
Well, it does look like it's daytime, so.
Right. We're certainly amenable to that, Your Honor.
Okay. Overruled.
Yes, Your Honor.
You may proceed.
Is the exhibit in evidence,
It
Your Honor?
is. It'll be admitted today's date over plaintiff objection.
Yes, Your Honor. And may I publish a few copies of that same photograph to the jury?
You may.
Thank you, Your Honor. All right, Mr. Shields, you would agree with me that there is a street light in this photo, right?
Yep.
You would agree with me that the street light is on the right side of the road, correct?
Yes, the side that I was driving on.
Exactly. The one street light in this photo is on the side of the road your car was on, right?
Yes, it was.
And again, by process of elimination, that means, sir, that there are no streetlights on the side of the road that Mr. Daly's car would have been on, correct?
Would have been on when I noticed it, or would have been on when it hit me?
When you noticed it, when you were able to see inside of his car.
Well, I was able to see inside the car when it came across the lane to hit me on my side of the
So
road.
that wasn't my question. There are no streetlights on the side of the road that Mr. Daly's car was on. Yes or no?
I'm sorry, I just don't understand at what point you're asking, because it was on all sides of the road. Like I said, it was swearing back and forth.
Sure, let's go chronologically then. When you first saw Mr. Daly's car, there were no streetlights on that side of the road.
No, there were not.
On the side of the road that Mr. Daly's lane would have been in going west, there are no streetlights.
No, there are not.
Thank you, Mr. Shields. Then I want to focus on what else you said about the accident. Sir, you would agree with me that you only had a couple of seconds to look inside of Mr. Daly's car, right?
That's right.
It's your testimony to the members of the jury that what you saw in those couple of seconds was Mr. Daly slumped over the steering wheel of his car.
Yeah, when someone's about to hit you with a car, you don't forget that. So I saw him slumped over the steering wheel.
Mr. Shields, you don't know why he was slumped over the steering wheel of his car, do you?
No, I do not.
You don't know if he was leaning over, changing the dial on the radio, do you?
No.
You don't know if he was picking up something off the floorboard?
Nope.
Objection, Your Honor, speculation.
Maybe her.
Yes, maybe her.
That's exactly the point, Your Honor. We're saying what this witness doesn't know. We're not asking him to say what he was doing. We're saying that he doesn't know these things.
Okay,
Your Honor, may be heard.
sure.
In that case, actually change my objection to cumulative. The witness has already testified he did not know why Mr. Daly was slumped over, so to ask him all of the different reasons why he didn't know
Now,
would
that's
be
a good
cumulative.
objection sustained.
Yes,
Maybe.
motion to strike.
Yes, I'll let you be heard, but he said he doesn't know, so.
Certainly, Your Honor.
But go ahead.
So the standard under 403 is that testimony should be excluded where the cumulative nature of it is needless. In this case, it's certainly not needless. Here, we're eliciting the fact that the plaintiff seeing this person slumped over the car is the only proof of anything about a seizure that the plaintiff has, and bringing this lawsuit and alleging that the plaintiff saw this seizure. It's certainly not needless to go into this line of questioning. It's a part of the defense's responsibility to attack this
I'll give
testimony.
you one more question on those lines. Go ahead.
Yes, Your Honor. The fact of the matter is, Mr. Shields, you don't know if it was, let's say, medication that caused Mr. Daly to slump over the steering wheel of his car, right?
No, how would I know that?
Exactly. Now, Mr. Shields, the first time that you noticed Mr. Daly's car was when he was about a block away, right?
That's right.
And you said on direct examination that you thought he was drunk.
I'm not sure if I did say that on the direct examination, but I did think he was drunk.
Sir, that was concerning to you, wasn't it?
It was.
It was concerning seeing someone that you thought was drunk on the road.
It was.
Because, Mr. Shields, we're reasonable people. We can agree that drinking and then driving isn't safe.
Drunk driving is very dangerous, that's correct.
Well then, Mr. Shields, focusing on the accident specifically, you would tell the members of the jury that you actually remember nothing about the impact, do you?
No, I do not.
Sir, you remember nothing about what happened just after the crash, do you?
No, I do not.
And sir, you would agree with me that since this accident, your memory has been foggy.
Yes, it has.
Thank you, Mr. Shields. I have nothing further. You can close that binder you have in front of you.
Very well. When you redirect